This is Bloomberg Law with June Grasso from Bloomberg Radio.
Special counsel Jack Smith has recalibrated the indictment against former President Donald Trump for trying to overturn the 2020 election. In order to comply with the Supreme Court's ruling giving presidents sweeping immunity for official acts. The superseding indictment reworks the language and removes some allegations, but the 4 criminal charges against Trump remain the same. Joining me is Dave Aronberg, Palm Beach County State Attorney. What do you make of the special counsel filing to restart basically both cases this week, Monday and Tuesday, 1-2 punch?
Jack Smith had to do what he had to do because the Supreme Court pushed him into this situation, and Judge Cannon in South Florida pushed him into this situation. So he's just reacting to outside forces. This wasn't something that he wanted to do before the election to try to make it an election issue. He was just being a lawyer, following the evidence and the law and doing what the law required. And so I'm glad he did this because I've always thought that, at least in the D.C. election interference case, that the Supreme Court's immunity ruling really does not gut the case at all. I mean, he got a shave around the edges, but other than that, the heart of the case still remains.
So you weren't surprised that the 4 charges are the same?
No, I would be surprised if it weren't the same because the only part of the D.C. election interference case that needed to be excised was any reference to Trump's alleged influence on the Department of Justice to try to pressure the states to redo the election, to accuse the election of being fraudulent, to threaten to remove the acting attorney general unless he did Trump's bidding. That stuff, according to the Supreme Court's immunity decision, is all covered by presidential immunity because it's within his core duties to name an attorney general, to have an executive branch that works with and for him. So he's able to get away with that. Now, if you think, well, Jeffrey Clark now is scot-free, no, Jeffrey Clark, who was allegedly the coup leader within the Department of Justice, could still face justice elsewhere. He was not even charged in the D.C. election interference case. Remember, one of the powerful things about the D.C. election interference case is that only Trump is charged there. That case was built for speed, and it's going to go first, I think, after the election if Trump does not win.
Chief Justice John Roberts, in the immunity decision, wrote that a president is at least presumptively immune from prosecution for his interactions with his vice president about constitutional duties, including the vice president's conduct in overseeing the Senate. Is that going to be the most perhaps problematic part of the superseding indictment in that it keeps in evidence about Trump trying to pressure Pence into disrupting the electoral count?
I don't think so, June, because all of that can be overcome. It's a presumption of immunity. You just have to show that by prosecuting the president, it does not impinge upon the powers, the official acts of a president. You don't want to diminish the powers of a president by going after a president for talking to his vice president. And the reason why it does not impinge upon the core powers of a president is because he was not talking to Vice President Pence as a member of his team from a White House perspective. It was as a candidate for office. He was talking to Pence to help fix the election. He was talking to Pence as an office seeker, not an office holder. And also, in any event, Pence was acting as the president of the Senate, not as vice president per se. And so that's another way you get around it, was that this does not hurt the powers of a president to say you're going to be held responsible for your improper communications with Mike Pence as the president of the Senate. Now, if you were talking to Mike Pence about foreign policy in his role as vice president, yes, that would be protected. But not when it comes to Trump trying to overturn an election, which is not an official act, as a candidate for president, not as the president, as a candidate, and in so doing, going after Mike Pence as the president of the Senate, not as vice president.
They changed the tone of it by changing the wording. For example, in the first paragraph before, it described Trump as the 45th president of the United States and a candidate for re-election in 2020. This time it describes him just as a candidate for president of the United States in 2020. Are those little fixes important?
Yes, because they are emphasizing Trump as an office seeker, not as an office holder. They want to try to convince the future appellate courts that Trump was not acting in his official capacity, because this Supreme Court decision is broad and it is confusing. And Jack Smith went up and down the chain at DOJ talking to the Solicitor General and others to come up with wording that they thought could pass muster, and I think that he did.
The Supreme Court's opinion basically changing what people thought the law was, and yet there's very little guidance in that opinion for prosecutors going forward.
Yeah, I think that opinion should have been revisited. It was confusing. It was way broader than necessary, and it's going to, at some point, I think, be addressed again because of the confusion it's putting out there. I mean, I do think at some point, maybe when there's change in the Supreme Court, that this decision will be reversed, just like others in the dustbin of history have been reversed, like Plessy versus Ferguson, Korematsu. There are a litany of bad decisions that have been reversed over the years, and I think this will be one of them, because they took something that doesn't exist, presidential immunity. I mean, before this opinion, presidential immunity existed in the civil context, but not in the criminal context. And the way they broadened it gave the executive branch unprecedented powers that never existed before. And it has set forth all this confusion that not only can you not prosecute a president for his official duties, and they've defined that very broadly, but you can't even get evidence of unofficial acts, criminal unofficial acts, by way of his official duties, meaning that you can't go and interview Department of Justice officials to find out that the president may have sold pardons for bribes, right? So the way they've done it is not just hurt prosecutors when they can't prosecute a president for official acts, but they have kneecapped prosecutors in their investigations, where you can't even investigate a president when he's doing something within his official sphere, even if it involves a criminal act.
Also, the revised indictment removed references to Trump's conversations with his White House aides and lawyers. In a brief accompanying the new indictment, the prosecutors noted that the revised charges had been presented to a new grand jury that had not previously heard evidence in the case. Explain why that's important.
The prosecutors are going to be really careful. They want to make sure that they are not going to risk getting overturned on appeal. And, well, first of all, the old grand jury doesn't even exist. That's part of the problem. The old grand jury has been dismissed. They don't last, 2 years. It's been dismissed by this point. So they had to go to a new grand jury. But also it's good to show that they got it to a fresh pair of eyes, and that it wasn't tainted by any bias from the last go-around. Like, there wasn't evidence presented to the grand jurors this time around that could not be eventually used in a trial, because the Supreme Court limited the kind of evidence that you can use against a president. They've expanded immunity so much that it really does tie the hands of prosecutors. So the prosecutors understood this. They presented the limited evidence they're allowed to present, evidence that one day could come out in court. They went before a new grand jury. There is no taint here from the prior grand jury, from the prior indictment, and I think it's game on.
Let's talk about what happens next. The two sides are going to present papers to Judge Chutkan on Friday suggesting how they'd like to move forward, and then there will be a hearing next week. Will the defense object to the superseding indictment, and then we have more hearings? What do you think's next?
Delay is their middle name. They're going to keep pursuing delays. They're going to say that this superseding indictment was meant to influence the election and it should be delayed. This is election interference, which is ironic because Trump is being accused of election interference. And they'll find creative ways to say that the indictment still violates the Supreme Court's mandates in the immunity decision. And then once they get a negative ruling from Judge Chutkan, they're going to then appeal it. And, they just want to forestall this as much as possible. Ideally for them, they want this trial to take place half past never. And I think that they'll get what they want if Trump gets elected. Trump will just tell his new attorney general to dismiss everything. But if Trump loses in November, then this will be the first trial that he faces after the election.
The Supreme Court directed Judge Chutkan to determine which allegations in the indictment involved official acts by Trump. Do you think that she can decide about this superseding indictment and whether it comports with the Supreme Court's decision without calling any witnesses?
That's a really good question, because a lot of us expected her to have a mini trial, which would be an airing of the evidence. Mike Pence would get on the stand, and it would be really compelling. And it would happen before the election, and the public would learn about Trump's involvement before, during, and after January 6th, even though there would be no trial until after the election. But according to recent reports, Jack Smith and his team are not going to push forward for a mini trial. Ultimately, it's up to Judge Chutkan to decide. Judge Chutkan could decide that she can make these decisions based on the paperwork, the pleadings. You don't need verbal testimony, but it will be up to the judge to decide. And then the question is, when would it happen? Would it happen before the election or after? These are the questions out there. I think that you can do a mini trial before the election. Ultimately, the decision on whether to have a mini trial should be based on the evidence and the law and should have nothing to do with politics. You shouldn't be concerned that there's an election around the corner, and you shouldn't be concerned that people are going to interpret it as being political, because whether you do or you don't, you're going to be accused of being political in this day and age. In this political environment we have, you're always going to be accused of weaponizing the Department of Justice, even though you're not. So you just follow the evidence and the law and tune out the noise.
But there is so much noise, Dave. Thanks so much, as always. That's Palm Beach County State Attorney Dave Aronberg. The Supreme Court refused to reinstate President Biden's latest push to reduce student loan bills for millions of people, keeping the plan on hold while the legal fight over educational debt plays out. The court turned away an administrative request to lift a pause a federal appeals court imposed on the program in a lawsuit by Republican-led states. The order didn't indicate that any justices dissented and gave no explanation, saying only that it expected the appeals court to issue a definitive ruling in the case, quote, with appropriate dispatch. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.